I'm going to explain workers' compensation and the interplay with an injury case. First, it's important to understand the basics of workers' compensation before we move on to the interplay with an injury case. What most people don't realize is workers' compensation covers all on-the-job events that result in an injury. What really happens is when somebody is working, you have a contract. People don't have to have a written contract for there to be a contract. There are contracts that are what's called inferred by law. So an employment contract exists regardless of whether you have a written contract or not. And the contract terms are pretty simple. The salary that somebody receives is provided in return for the services they've agreed to provide, no matter what it is that they're doing. That's a contract. The law infers in that contract of employment various terms. There are Department of Labor laws that employers must comply with, regardless of whether you have a written contract or not. One term that's implied in every employment contract is that an employee is not allowed to sue their employer for an injury on the job. To give up the right to be able to sue your employer, an employee gets something very significant in return. The employer must provide workers' compensation benefits. So it works like this. Anybody on the job who is injured in any way is entitled to recover from their employer workers' compensation benefits. In very broad strokes, workers' compensation benefits covers economic loss. Economic loss is wages and cost of medical expenses. So anybody working who's injured on the job cannot sue their employer, but must file for workers' compensation. In return, the employer must provide those workers' compensation benefits. So you may ask, well, why is there a workers' compensation judge and isn't that a lawsuit? It really is not technically a lawsuit. It's a claim for benefits that must be provided. Simply because somebody makes a claim, it doesn't mean that the workers' compensation insurance company must pay that claim. And that's where workers' compensation judges make a determination as to whether or not the employee is eligible. Were they actually working at the time? Were they in the course of their employment when the event happened? And what are the benefits that they're entitled to? So it's really a claims-based, non-litigation-based system. And the purpose of it and the social benefit of it is we don't want employees thinking of how to sue their employer to recover benefits for injuries on the job. So workers' compensation, very broadly, is any on-the-job event that results in injury. There's one very important word that I left out. The word is fault. It's regardless of fault. Everybody is entitled to workers' compensation benefits. So in an extreme example, if somebody is sitting at their desk, leans over, and in an effort to pick up a garbage can, tweaks their back. Simple question is, were they in the course of their employment? Yes. Were they injured? Yes. They're entitled to workers' compensation benefits, provided they notify a supervisor within a defined period of time. Once you have established your case for workers' compensation benefits, then the system basically takes over and you're entitled to those benefits. The important word of fault is removed because we want people to readily have access to medical care and not subject any harms, economic harms that is, when it comes to an on-the-job event. But when somebody is injured on the job and it is through somebody else's fault, and I want to define somebody else, they may be entitled to seek a claim against that other causative party, the person who caused the injury. So the workers' compensation, and when an employee gives up their right to sue their employer, it's broader than simply their employer. It also includes a co-employee. So if anybody is on the job and a co-employee or their employer does something that results in injury, you're limited to workers' compensation. But if you're in the course of your employment and somebody or a corporation other than your direct employer or a co-employee of the same employer, then you are entitled to recover, and possibly from what's called a third party. And let me just take a moment to define the distinction between first party and third party. When two parties or people have a relationship with one another, that they have agreed upon the terms of that relationship. Any contract that somebody enters into with somebody else, that creates a first party relationship. So an employee-employer relationship in law is considered a first party relationship. It's governed by the terms of that contract. And as I mentioned, sometimes the contracts are in writing, but sometimes those terms are defined by law and different statutes as to what is considered part of an employer-employee relationship. When an event is caused by somebody other than a first party, that being somebody you already have a relationship with, and clearly I'm limiting it to a legal relationship with, not a social relationship. If you have a legal relationship with another party, that's a first party relationship. And if a injury producing event is caused by a third party, and I'll define a third party. A third party is a corporation or an individual you do not have a legal relationship with. You may have a social relationship with, you may know of and be aware of the other party, but if there's no legal relationship in law, it's called a third party. So when somebody is in the course of their employment and there's an injury-producing event that occurs, the individual, the employee, is entitled to first their first-party benefits, workers' compensation, and potentially make a claim against the third party who caused the injury-producing event. In the third-party claim, which is a personal injury claim, that's where fault comes into play. The injured party must show that the causative party, whether it's an individual or a corporation, did something that a reasonably prudent person would not have done had they been in the same situation, the definition of negligence. Please take a look at my other video where I go through a full explanation of what negligence is. But suffice it to say, the negligence is defined as when somebody fails to act like a reasonably prudent person, and it's foreseeable when they act that way, it may result in physical injuries to somebody else. When that occurs, they are fully responsible for all the damages that are caused. Now, some scenarios, if an employee of, let's say, a driver of a bus company, they are in the course of their employment, whether it's a school bus or a transportation company, and they're driving the bus and they enter an intersection with a green light, and coming from one of the side streets is another vehicle that strikes the side of the bus. 100% the responsibility of the car that enters the intersection with a red light, and the bus has a green light. The driver of the bus who is injured, because they are in the course of their employment, is entitled to workers' compensation benefits. Those benefits, as I've defined, are limited to economic loss. Economic loss being lost wages and medical expenses. They can, in addition, also make a claim against the driver of the car and the owner of the car who caused the crash and caused their injuries. That would be called a third-party lawsuit. What is available in a third-party lawsuit? Everything that is available in any traditional negligence injury lawsuit, which is economic loss and non-economic loss. Here too, I've done another video which fully explains what is available in injury cases, and I encourage you to watch that. But when a claim is made against a third party, the causative party, when you're in the course of your employment, you can get your full benefits. Now, you may ask, why would I do that? The significant difference is workers' compensation only covers economic loss, your lost wages or your medical bills, but it provides no compensation for you as an individual and anything related to the insult to your body, physically or emotionally, what happened as a result, which is called pain and suffering. So in workers' compensation, there's no award ever for pain and suffering. And in a third-party lawsuit, you are entitled to recover compensation for any pain and suffering that you may have suffered. So you may ask, well, why would I go forward and do that? The reality is the smaller part of most claims is the economic loss, the lost wages or the medical expenses. The medical expenses simply are to make the doctor whole, to make sure that the doctor gets paid. The lost wages are to make sure that you've recovered the economic loss that you've suffered. But the true harm that's caused in an injury case is the physical injury to the individual, the pain and the change in the quality of life that occurs when a significant injury happens. So a third-party case allows an individual to recover the full loss and be made whole to the extent that money can make somebody whole. In our society, the only thing that one is allowed to recover following a catastrophic event or any physical injury is money damages. We do not have laws that allow us to inflict the same pain as they did back in the old Roman days on the person who caused it. If somebody caused you to lose an arm, they took the arm off of somebody else. We don't do that. We've evolved as a society, and what we've said is we have to make the individual who's been harmed whole to the extent that money can do so. And ultimately, a jury decides what it is, the dollar amount that makes somebody whole. But in a third-party case, the injury case that flows from an injury that happens on the job when somebody other than a co-employee or your employer causes the injury, you are entitled to recover the full availability of all damages that you've suffered. One important note to realize in America, we're not entitled to a double recovery. So the scenario that I've outlined where the bus driver is in the course of their employment, there's a car that enters an intersection and is wholly at fault. The bus driver has started and has been receiving workers' compensation benefits, but is also making a claim against the owner and operator of the car for their economic loss, the equivalent of workers' compensation benefits, and their non-economic loss, their pain and suffering. You may say, isn't that a double recovery? Well, anybody who's in the course of their employment, their workers' compensation insurance company has an automatic lien, which means injured individual must make the claim against the negligent party, the third party, for both workers' compensation, economic loss, and non-economic loss. Should the injured employee recover, they must pay back a portion of the workers' compensation benefits that they've already received, so there's no double recovery. Now, Oftentimes, the workers' compensation will compromise, reduce what they are owed back, and there's a negotiation that occurs. But the claim must be made to recover everything that has been received from workers' compensation so that that can be paid back. But that's not the purpose of bringing a third-party lawsuit. The purpose of bringing a third-party lawsuit is for all of the damages that aren't covered by workers' compensation, which is the injury, pain, and suffering part of the claim. So that's a quick synopsis of the interplay between workers' compensation and a third-party lawsuit.